Hello, everybody. We're going to get started. A couple of notes of introduction and comments, and then we'll kind of launch into the presentation. My name is Jamie Dreyer. I'm a partner in the Downey Brand Law Firm's Financial Restructuring and Commercial Law Practice Group. This is, I think, the 8th Friday in a row or thereabouts that we've been giving these webinars, trying to keep our clients and friends and partners up to date on the things that we are seeing in the marketplace, things that we are dealing with on a constantly evolving basis, and our clients, a lot of which many of you on the line who are clients and friends and interested folks probably know about. We're going to get into some detail, keep you abreast of current developments, and I hope you get something out of it. Some of you on the line are clients, some are not. Please don't take our presentation as formal legal advice. I just got to provide that disclaimer. If you have any specific questions to your situation, reach out to your lawyer or to one of the folks on the line before you take any action. I think this is going to be the last in the line of these Friday general webinars where we've been kind of covering and hitting some quick hit discussions on groups of practice areas and issues. We're going to keep our webinar series going, but we're going to morph or shift it into more trade and industry and practice specific presentations. So let's see, at the bottom of your screen, there should be a blue chat bubble. If you have any questions during the course of the presentation, click on that chat bubble. You can send a question directly to any of us who are the presenters or to everybody on the line. It will show up on our screen internally. We'll keep track. We will try to, if we can, hit some questions during the presentation. If not, we're going to reserve a few minutes at the end to address some of them. Feel free to interact with each other as well. Let's see, today's panel. First up, we're going to have a brief update on employment and workplace issues from our employment law partner, Liz Stallard. After Liz is done, Steve Hymas from our corporate practice group is going to get into some detail on current and ongoing and constantly evolving changes to the Paycheck Protection Program, and I think specifically with regard to some thoughts on the loan forgiveness process and recent guidance issued. Next, the chair of our insurance coverage and insurance litigation practice group, Anthony Vignolo, is going to give a presentation on some relevant insurance coverage and claim issues in this environment. To the extent there's time, I'm going to chime in at the end and talk about some general economic issues, a little bit of data about what is going on out there, and then some very specific issues and immediate developments in the California legislature that as recently as last night have come out and talk about landlord, tenant, and lender issues and how that is affecting most of our clients. So with no further ado, I'm going to kick it over to Liz. Liz, go ahead.
Hi, thank you very much, Jamie, and good afternoon, everyone, and happy Friday. For those of you who can remember that today is a Friday, it has been a challenge over the past few months, so congratulations on us all getting here. As Jamie mentioned, I'm going to go ahead and walk us through the employment update part of today's seminar. And at its most basic, I know, especially for those of you who've been tuning in over the past couple of months, we have covered a number of the regulatory topics, and I've covered some of them as well as my partner, Kat Farinini, and I thought it might be useful today, especially since we're basically kind of turning the corner on businesses reopening, to talk about a few issues that are going to matter to those of you in particular who are now adjusting or perhaps even opening your workplaces because requirements in your locality are changing. And so the first question I have on my list is, what happens to the emergency benefits under the FFCRA, the Federal CARES Act, after employees are allowed to return to work? And at its most basic, what I can tell you here is, if you have been an employer who either had everyone home teleworking or perhaps your doors were closed and your operations were not going on, the biggest adjustment we have right now is that these are a whole new group of employers who now have to make sure that they catch up on everything that's been going on since COVID-19 kind of hit our community. So what that means is, for example, while you may not have had an obligation under the Federal CARES Act requirements to provide the emergency paid sick leave or the emergency family medical leave act leave for people staying home to take care of a child whose school is closed, Now, if you are reopening, now if you are asking those employees to come back into your workplace, you also now have to deal with the corresponding obligations you have to provide that kind of leave. Again, I know we've gone over them in detail in prior webinars, but just to remind everyone, the Department of Labor provides these two kinds of leave. At a minimum, if you're a covered employer, you're going to need to go ahead and make sure that you post those requirements in your workplace, especially if you're welcoming people back now. You want to let them know about this available leave, and make sure that if you have individuals who seek to obtain the leave, that you have a process in place to handle it. And I can't stress it enough. I think it's one of those challenges right now. Going back to normal, one of the hurdles you have to get over is making sure that you understand all the new obligations you have as an employer once you try and get your business operation running again. I would say also that another issue that's going to come up here is making some decisions about, first of all, if you're going to have some workers come back to your workplace versus leaving them in a telework capacity, because that does impact their rights to these kinds of leave. Keeping in mind issues related to the end of the school year and the potential reopening in your community of daycare and other kinds of providers. And so you may have to wrangle with those issues with your employees. And then, of course, thinking about the corresponding impact on your employees' entitlement to unemployment insurance, disability benefits, other things that they may have been obtaining precisely because they were not allowed to come back to work or you had no work for them. Now, obviously, that dynamic is going to change, and you have to be really thoughtful about how you structure your return to work to make sure that you're aware of those obligations and that your employees know what rights they have. So with that, the next question I have on my list is how to address employee concerns about safe interactions with customers. And so again, I think this is one of those topics that really any kind of business that opens itself up to the public needs to think about as you try and restart your operations in a more normal way. There is a lot of guidance out there, the punchline of it being before you open your doors, as you bring people back, you really should have a thoughtful and I believe written plan that goes through your facility, that thinks about the social distancing issues, the physical barriers, the workplace locations, all of those things that can impact safety, impact spread of the virus, educating your workforce. Part of that has to be what do you do when you have people coming on site who are not your employees. So, for example, you may have a written policy that says that everyone has to make the commitment to wear masks when they come on site, and certainly some of you may be aware of businesses who already have those in place. And of course, let me put the caveat there to say, if you are in a locality where that enforcement has already occurred, where you have an obligation in your county to wear masks when you're out in public, this is default, right? You don't have the ability to stray from that. But I would say even in those counties where there isn't a mandatory legal requirement, you may decide to protect your employees and also to protect the public that you want to impose this requirement anyway. If you are going to do that, again, I think any kind of policy that's going to impact your visitors and the public, you should have it in writing. You should have a clear understanding not only as to what the policy is, but also why. So, for example, using the mask requirement as an example, you should provide some explanation to your employees as to why you're requiring them, how they wear them, right? You know, what to look for in terms of whether people are complying with the policy. Don't simply tell your employees, make sure everybody has a mask on, right? Make sure it's thoughtful and that your employees understand what the requirements are. I would also say that you want to provide advance notice of any sort of restrictions you're putting on the public, not only to your employees, but the public themselves. So, for example, if you are planning on limiting public access to certain areas of your facility, if you're planning on limiting in-person meetings or solicitations, say, by vendors, you should think through those policies and make sure you let the people who come on site know that that's the way business is going to be, at least for now, right? And that may mean posting it at your entrances and also sharing it electronically and via social media. The other thing I would say is make sure your employees understand what to do when the policies are violated. I'm sure we've all seen things on social media where we have staff, employees being confronted by members of the public who don't like policies that a business has put in place with respect to dealing with the pandemic. It's important, one, that your employees know what to do if someone is not complying with the policy, and that what to do may be who they call, making sure that they have ready access to that so that they can de-escalate the situation. It may mean restructuring your staffing to make sure that you have people available, to just walk over to where the conflict may be occurring. Maybe that's stationing people at entrances because that may be the easiest way to identify noncompliance is when you see people coming in the door. And then also it's important, I believe, to think through the alternatives when you have someone who presents and says, and again, we'll use masks as an example, well, I can't wear a mask because I have a medical condition, so I can't do that. Okay, so maybe you're a retail store and they're there to purchase something. What's an alternative that you could do to help them still purchase their goods or perhaps help them to obtain the services they need? It's important to think about those kinds of problems or issues in advance so that you're not scrambling if and when they occur. And obviously we can't imagine every possible scenario, but all of you probably know best in your own business what are the most likely issues that may come up if you start restricting access, if you start requiring additional precautions to let people on site, things like that. And it may in fact involve you enhancing some portions of your infrastructure as well. If you haven't already updated, the ways that you communicate electronically, for example, you may find yourself needing to do that now simply because you have a system in place that isn't allowing people to interact in person as much, for example. The last thing I want to stress in this point is other physical considerations that you should make thinking about the interaction between your own employees and the public or your customers. Certainly, think about the fact that you may need to open up more slowly than you might otherwise anticipate to make sure that you can handle the new restrictions with your regular flow of business. So maybe that means more things like soft openings. Maybe that means taking fewer orders the first few days you're open, so you make sure that your employees who are also complying with these other physical distancing and other requirements can still get their jobs done and you don't disappoint your customers in the process or cause people to cut corners. All of those kinds of considerations are going to matter so that you know that your process works and that you can still fulfill the obligations of your business. Another key consideration would be sufficient staffing, not just with respect to the work that needs to be done at your business, but you should also consider whether you need to provide additional staff that are solely tasked with providing security or enforcement of any policies you put in place on site, at least temporarily. And then finally, think about physical space concerns. Really focus on looking at your business location. What is the best way if you're imposing certain restrictions? We're only going to let so many people in the store at a time or in the sales area at a time. Okay, where are they going to wait? How are we going to let them know that they have to wait? How do we keep them safe while they're waiting? Things like that you need to work through that are very specific to your site. And obviously those are the kinds of considerations that really matter when you finally have people coming in the door. You want to know what the plan is before they get there. And you also want your employees to know how to enforce and direct people to comply with the requirements you've put in place. And then the last thing I have on my list to talk about today is temperature checks. And again, this is something that we have discussed before, but really now, because I think in particular we have a lot more people coming back on site, it's important to remember what your freedoms are and certainly what your obligations are if you're going to go ahead and start temperature checking your employees when they come on site. The EEOC has updated its guidance. It's specific to COVID-19. I'd also want to note again, there are some localities that have put in place requirements for temperature checks. So certainly if you have an obligation that exists in local law, you want to make sure you know about it because it may provide different or additional requirements than what I'm going to talk about today. But at a minimum, well, if we assume that, and based on the EEOC's guidance and what's come out from the federal government, we are allowed to take the temperatures of employees precisely because they've identified COVID-19 as a direct threat due to their medical condition to protect the other employees. Let's assume you want to put a temperature check requirement into your workplace. Well, how should you do it? First of all, again, if you're going to impose this kind of requirement on your employees, talk to them about it first. Explain sufficiently in advance how it's going to be run, why you're doing it, what a test result that makes them have to go home is going to be, just so that they understand the process and they are familiar. Next, in terms of that threshold, the CDC's definition of a fever is 100.4 degrees. That should be your threshold. You could certainly set it lower than that. I wouldn't obviously tell you to set it any higher than that. But I know that there's some businesses who've just said 100 degrees because they feel like that's simpler. Again, 100.4 is the CDC standard, and it's probably a safe default. And the third thing I would say, and the most important thing about the process, is making sure that you facilitate this testing in a way that not only maintains the confidentiality of medical information for your employees, but also keeps folks safe when they're coming on site and you're checking them. And so there's a few things to think about there. Certainly, if you're temperature checking your employees, you want them on the clock when you're doing this, right? So they come into work, they check in, and then you're going to do the temperature check. Depending on the number of employees who are coming in at any particular time, you may need to think about, do I need to have multiple thermometers to check? Do I need to have multiple areas where people check in? Do I need to stagger arrival because I don't want too big of a backlog, right? You don't want people standing around for a half hour, so maybe we need to do something different there. These are all considerations that will be impacted by how your business operates. The other thing, of course, is the reason you're doing this is because if someone has a fever, you're going to want to tell them to go home. So you don't want them all clumped up with each other waiting to get that temperature check done. You need to structure the area where they're going to have temperature checks in a way that maintains social distancing and other guidance that we have to reduce the spread of infection. And of course, we want to make sure that people can't overhear or otherwise engage with conversations about the medical condition of their fellow employees in order to maintain employee privacy. So that may mean a separate room where this happens. It may mean identifying a minimum distance where the line has to be from where the temperature check is being taken. And of course, making sure that the personnel who are taking temperatures are qualified and trained, not only in terms of the medical thing that they're doing, but also that they understand the privacy rights of employees and don't violate that by, saying something out loud, oh, we got one, something like that. And of course, if you've been on this planet for more than a year, I feel like everyone is, knows someone who's going to forget. And so I think it's really important that you remind your staff and that you have people there who know how to behave if they get a reading, who are appropriately trained in terms of wearing their own protective gear, right, that they're maintaining best practices, so you don't end up by way of doing something that's intended to keep your employees safe by actually putting more employees in jeopardy, right? Or potentially bringing up potential claims against you because you didn't do this the right way when you decided to implement it at work. And with that, I will go ahead and I will pass the baton over to our next speaker. Thanks, everyone.
Thanks, Liz. And this is Steve Hymas, and good afternoon, everybody. I wanted to follow up on recent updates regarding the PPP, in particular updates regarding loan forgiveness. And as many of you know, over the last few weeks, the SBA issued evolving guidance that created a lot of issues and concerns for borrowers. And a lot of this started with guidance on May 3rd in an FAQ number 31 by the SBA. And in that, the SBA indicated that borrowers need to review their certification to make sure that they were necessary, that if a borrower applied for a PPP loan prior to the updated guidance, but was willing to repay the loan by May 7th, that it would be deemed to have made the certification in good faith, and that the SBA would review all of these loans in excess of $2 million and other loans as appropriate to see if they were justified. All of this new guidance that the borrowers received created a great deal of concern because they didn't know whether they would get audited, whether they would or would not have their loans forgiven, or whether the SBA would pursue other punishment against borrowers that had gone after these loans. After this backlash that the SBA received, they followed up with additional guidance which softened their position, which honestly was a good help for many of the borrowers that we've worked with. And for example, in the FAQ number 46, the SBA stated that any borrower, together with its affiliates that received PPP loans that were less than $2 million, would be deemed to have made the required certification in good faith. The SBA also added that any borrower with a loan greater than $2 million that doesn't satisfy this safe harbor that they created could still have an adequate basis for making their required good faith certification based off of their circumstances. The SBA followed and noted that in its review of loans over $2 million, if it determined that a borrower lacked an adequate basis for the certification, the SBA would seek repayment of the loan balance and inform the lender that the borrower is not eligible for forgiveness. And the SBA clarified that if the borrower did repay the loan after receiving that notification, that the SBA would not pursue administrative enforcement or referrals to other agencies. So this updated guidance helped reduce some of the concerns that were created by its original guidance, but it highlighted some concerns and issues that borrowers need to pay attention to going forward, including how to make sure that they'll qualify for loan forgiveness and that they can certify that the loan was made in good faith. And with respect to loan forgiveness, we've received additional clarification to help borrowers understand how to proceed. And this guidance can be used not only to fill out the application that the SBA provided, but can also be used to help you track how you're spending on the loan amounts that you received and how you're tracking those loan amounts so that when you get to the end, you can justify both the loan and the use of the proceeds in order to show that you qualify for forgiveness. And this application that was provided by the SBA over the last week, it contains a three-part calculation to determine the amount of the forgiveness. And it follows three of the major criteria that have been discussed with the SBA loans on prior webinars about what the needs are in order to qualify for a forgivable PPP loan. For instance, the first qualification is basically to measure both payroll and qualifying non-payroll costs that the borrower spent over its 8-week measurement period. The second criteria is to determine if there's a reduction in the forgiveness amount that the borrower would be eligible for based off of whether the borrower reduced its pay for employees by more than 25%, or if the borrower had not brought back the same number of FTE employees. And then the third step is the payroll cost test, which basically states that the forgiveness request must be comprised of at least 75% in payroll costs, and then the other 25% can be used for qualified non-payroll costs. And then within that laying out of the criteria, the application also provides additional clarity over several points that have been questions of confusion or concern over the life of this PPP program. For instance, in the application, it defines payroll expenses, and it provides that payroll expenses include gross salary, wages, commissions and tips, paid leave, allowance for separation or dismissal, employee contributions for health care coverage and retirement plans, and payments for state and local taxes assessed on the compensation. It also includes a cap of $15,385 per each individual over the 8-week period. And this $15,000 number is basically the amount of the $100,000 cap that was in place on annual wages, calculated per individual over the 8-week period. The application also gives additional clarification on what qualified non-payroll expenses would be. And this includes mortgage interest payments for debt incurred prior to February 15th, and it's for both real and personal property. It includes rent or lease payments on real or personal property for leases in force before February 15th. And this additional guidance is helpful because beforehand it wasn't clear if rental payments for personal property can be included, and now that's been clarified. It also adds utility payments as qualified non-payroll expenses, and this would cover things like electricity, gas, water, transportation, telephone, or internet access for any of these services that began before February 15th. The guidance also helps clarify what the 8-week period would be for each borrower. And basically, you're allowed to use two different methods. You can use either the date the PPP loan was dispersed, or for any borrower with a biweekly or more frequent payroll schedule, it can also use an 8-week period beginning on the first day of the first payment period following the loan disbursement. And this was meant to help borrowers that have businesses that run on these types of payroll periods so they can line them up with their loan. The other point that was clarified in the application is how you would go about calculating FTEs. For instance, a borrower can use a period starting from February 15th to June 30th to measure FTEs, or it can use January 1st to February 29th as a reference for measuring FTEs. It also allows for seasonal employees to use a 12-week period that would be between May 1st to September 15th. And lastly, a borrower will not be penalized for any reductions in the FTEs if the borrower made a good faith written offer to hire an employee during the 8-week period and that was rejected by the employee, or if an employee was fired for cause, voluntarily resigned, or voluntarily requested a reduction in hours. In addition, there is also a safe harbor for any borrower that reduced its FTEs between February 15th and April 26th, but they're able by June 30th to get their FTEs up to the level that existed before February 15th. There's additional clarification in the application as well on what documentation will be required for the forgiveness request, and there's a certification that a borrower must make regarding the total loan amount received by the borrower to certify if it's less or more than $2 million. So this certification could be used to flag borrowers with loans in excess of $2 million that would then fall in the potential audit parameters given by the SBA in its guidance. So it's really important to now look at that loan forgiveness application and to study it, not only so you're prepared when you want to apply for loan forgiveness, but also to help you start tracking the expenses that you would apply for the loan forgiveness and the documentation you'd use to support your loan forgiveness, and to show that the loan itself was necessary and your certification was made in good faith. And then the last point I wanted to address was that there's an additional legislative update that could be coming down the road regarding the 8-week period. Restaurants and other businesses have raised concerns about the length of the 8-week period, and they've raised that with Congress and the President. And several members of Congress over the last week have said that they're in agreement on revising the law to extend that period. Some members of Congress have proposed a period that would be around 12 or 16 weeks. And then President Trump on Monday said that he supported extending the period up to 24 weeks. So we assume that there will be some change in that period in the near future, but as of yet, there hasn't been a commitment on what the length of that period would be when that extension would pass, but we do expect to see something occurring in the near future. So it'd be good to stay on top of that, and that will help you again with following up on your loan forgiveness application and tracking what you need to do to document it. And with that, I'll turn my time over to Anthony.
Okay, thanks, Steve. I'm going to talk sort of at the 35,000-foot level on insurance. So, as most of you know, the main purpose of insurance, we basically pay a premium to shift risks that we don't want to take onto somebody else, usually insurance companies. Insurance policies are generally divided into two types. There's first-party coverages and there's third-party coverages. First-party coverages are the type of insurance policies that provide coverage for losses that you sustain. Most common example is a property damage policy. If your business burns down, if your house burns down, your insurance company theoretically will hopefully pay you out for the loss. That is a first-party policy. Third-party policies are policies that essentially defend and indemnify you against third-party claims. So when you get sued, when your business gets sued by a third party, theoretically those policies would kick in to provide coverage. Typical third-party policies are commercial general liability, director and officer, employment liability, those kind of things. So I'm going to talk a little bit about each of these types of policies, at least the main ones that I think could be triggered here in response to the COVID-19 pandemic. I'm going to start with the property damage policy. So property damage policy, again, just as the example I gave, generally it's a first-party policy designed to pay you for losses that you sustained. Now, obviously, a lot of businesses, especially the non-essential businesses that have been forced to close, their production's down. Maybe they have no production at all. They've certainly been hit financially, and certainly they're going to be looking toward their insurance companies to pay for those losses. Now, for a property damage policy to be triggered, there has to be physical loss or damage to the property. And I'm going to kind of back up here because what happened when COVID-19, when it first came out, the insurance industry actually preemptively responded with press statements saying that property insurance policies don't provide coverage for COVID-19 losses sustained by business. And they did this before policyholders even submitted claims. So consistent with the approach they took from the beginning, most businesses that are tendering claims under their property policies to their insurers are finding that the insurance companies are denying claims. Now, economically, they probably don't have much of a choice. The American Property Casualty Insurance Association did a study. They came out and said that virus-related losses to businesses with 100 or fewer employees would amount to between $220 billion and $383 billion a month in covered losses. So those types of claims literally would probably bankrupt most of the insurance industry. But nevertheless, you know, what the insurance companies have done in sort of categorically coming out and saying that these claims are going to be denied is wrong. I mean, there's just no basis to do a generic denial because by their terms, commercial property policies vary significantly. So as I mentioned, for a property policy to be triggered, there has to be physical loss or damage. Again, the most common example is, you know, you sustain losses to your business or your home by a fire. Certainly there's physical loss or damage. But other courts have interpreted and have been confronted with the situation where there's things like smoke damage. Does that constitute physical loss or damage? Now, if it does, if whatever the contaminant is, if a court says that triggers the physical loss or damage or meets that definition, then what happens is not only do you get compensated for remediating that physical loss or damage, but property damage policies also have business interruption coverage that also gets triggered when there has to be physical loss or damage, but once there is that finding, then the business interruption portion gets triggered to cover whatever business losses you've sustained as a result of the interruptions. You know, again, obviously, as I mentioned, our businesses have all been impacted, but the question now that's going to be in front of the courts, and that has been in front of the courts, is whether COVID-19 causes physical loss or damage to property, and the courts are mixed on that. You know, in the past, some courts have said that the presence of a contaminant, whether a chemical or a contagion, that impairs the use of property meets that definition of property damage. Obviously, insurance companies want to take more of a flat earth mentality, and they try to argue that if you can't see it, then it doesn't exist, and it can't be property damage. There was actually a federal court in New York that came out with its decision last week. I think it's one of the first decisions to come out. The case is Social Life Magazine versus Sentinel. And you had a magazine publisher that had its printing presses and everything else. And when they got the shelter-in-place order, all the employees went home. They obviously could not work from home because they needed the printing presses. And the owner of the company tendered the claim to the carrier, and not surprisingly, the carrier denied the claim. The business owner filed suit. And as I mentioned, the judge's decision came out last week, and it was in favor of the insurance company. So the business owner tried to make many creative arguments saying the employees can't work from home, they need the printing presses, even said, hey, the owner of the company tested positive for COVID-19, so there must be a real risk that the equipment in the building is also contaminated and therefore damaged within the meaning of the policy. So the judge came out in a decision and said you get an A+ for creativity, but there's no coverage because COVID damages the lungs. It does not damage property. So, what we're seeing is we're seeing a lot of insurance companies that they're especially going to be defending these initial cases very aggressively because they're trying to establish precedent that will be binding on other cases to follow. And I think we're going to get mixed results, just as we have in the past when the issue of property damage was some kind of contaminant. As I mentioned, courts across the country have really had mixed results on that. So it's unclear where California courts are going to come out on that. There's another aspect in a property damage policy that provides coverage for civil authority, so that these policies don't only cover physical loss or damage, but they cover losses from extensions of civil authority. Generally, what that means is losses when a government or military authority limits or prohibits access to your property because of damage to your property or other property within the area. An unfortunate example is when 9/11 happened. There were a lot of businesses that made claims because they blocked off that whole area for extended periods of time. Same thing is, is obviously is happening here. Non-essential businesses, as a result of COVID-19, have been ordered by civil authority to close. If you have a property damage policy, this is probably going to be your best and most clear-cut argument. There's a case that I wanted to mention. It's U.S. Airways versus Commonwealth Insurance, and that was a case out of Virginia. And I think the rationale of the court there is important. That was one of the cases that I just mentioned from the 9/11 example. So I'm going to quote from the court here. The court held that U.S. Airways merely had to prove, quote, that a civil or military authority issued an order which caused a denial of access to U.S. Airways property, and that order was issued as a direct result of a peril insured against. And the court found, quote, the order to close Reagan National was made specifically out of fear of being a target for further terrorist attacks. Closing premises acted to protect the property of not only U.S. Airways, but all other commercial and private operators at the airport. So the court found that there was coverage for the business losses resulting from that exercise of civil authority. I think that's going to be, as I said, your best argument. That's going to be a very close analogy to what's happening here with COVID and the governmental orders that have been issued as a result. There are going to be other potential coverages in a property damage policy that may apply. I'm not going to get into those. I just wanted to hit on the two most likely, which is the property loss one and then the civil authority one. Now, even if a court or an insurance company says that there is coverage under the insurance provision of your property policy, the next step is they're going to look to see whether there is an exclusion in your policy that removes that coverage. So far, insurers are saying most property damages have an exclusion for losses resulting from pollutants and contaminants. And generally speaking, again, these policies vary by terms, but generally speaking, the exclusions are for bacteria, mold, pathogens, and pathogenic organisms. There is no standard virus exclusion in property policies. So, what's going to be interesting is how the courts kind of interpret this and what the experts say about COVID. These policies really, by their terms, apply only to exclude losses from biological contaminants, again, not viruses specifically. And the standard reference to bacteria or microbes and the like in these policies, generally from a scientific perspective, they're referring to living things that eat and reproduce and respond to stimuli. Unlike viruses that are non-cellular strands of DNA, are not known to do any of those things. So again, the insurance companies are going to fight aggressively. There's going to be interpretation issues, but there is a decent chance that there will be coverage if you have a property damage policy under one of these coverage provisions. So the next topic I want to talk about, we talked about these are, property damage policy is a first-party policy that covers your losses. Then you've got other insurance policies that are referred to as third-party policies. And what those do is they cover you, defense and indemnity, in the event you get sued. So typically when we think about third-party coverage policies, we think about a commercial general liability policy, we think about a directors and officers policy, an errors and omissions policy, an employer's liability policy. All these types of policies that cover suits under different types of claims. So I'm not going to get into the weeds on these, but I think the main one that we really need to be thinking about here is probably going to be the commercial general liability policy, which is, in general, these policies are intended to protect businesses against third-party claims from bodily injury resulting from exposure to harmful conditions. So if your business is open and you have a customer who came in and said, I got COVID-19, it's from your business, and they file suit, your commercial general liability policy should provide a defense and indemnify you for any judgment that's awarded. But, it's important when we think about these third-party policies, there have already been several cases where the courts have addressed these in different contexts, and it's a huge variety of contexts. We've seen cases that are popping up now where shareholders are suing businesses saying that they did not effectively manage the COVID-19 crisis. The stock price fell drastically. So we're seeing these shareholder suits that are triggering E&O policies and director and officer policies. Again, we're seeing it in the commercial general liability policies where customers are claiming that they contracted COVID at a specific business and filed suit. So, again, these policies generally are designed to protect you against these third-party risks. So for the most part, there should be coverage for these third-party claims, probably a better chance of coverage on the third-party claims than you're going to see on the first-party claims. One thing that was interesting, I was reading an article the other day and it said, masks are not required to protect from the virus, but are required to protect from lawyers. And there's a lot of truth to that statement in the sense that, a lot of businesses are trying to be proactive and take these precautions so that they minimize their exposure to these lawsuits. In short, I'm going to say this. If you have an insurance agent or you have an insurance broker, meet with that person, review your policies. If you have losses, first-party losses, or if you get a third-party claim, you want to make sure that you tender it right away. There's time limitations under many policies that require that the claim be tendered to the insurance company within so many days. So understand your policies, dig them out, and if you do tender a claim, you can probably expect that the insurance companies are going to deny it. If you get that denial letter, don't put it away in your file cabinet. Bring it to your broker, go to a lawyer, and push back, because it's a very common practice for insurance companies to deny claims, and then once somebody does push back and say, no, this denial was improper, then all of a sudden they reconsider it and you get their attention. So I think that's probably it from my perspective.
Thanks, Anthony. This is Jamie Dreyer again. Again, my kind of practice focus is in the financial restructuring and commercial law group here at the firm, and so that means a couple of different things, but I work in the insolvency, the bankruptcy, loan negotiation, documentation, workout, and receiverships arena, which I might have something to offer you. For many of you on the phone, you probably don't want to talk to me or hear from me, but maybe I can download a little bit of data to help you be prepared for the future. So let me take you on a little ride. And that little ride is some economic indicator data I pulled up this morning. And this is maybe a little bit of just an intellectual exercise, and I don't mean to make anybody's stomach churn, but I think the real purpose for some of this is, one, just to understand what's going on, and two, therefore, to be prepared for it. So GDP in the first quarter, I think everybody knows what it is, dropped 4.8% at an annual rate. But it's expected in the second quarter to drop by 30 to 40%. So the first quarter was bad. The second quarter will be worse. The biggest consumer spending dropped 7.6% in the first quarter. Interestingly and understandably for all of you, the biggest decreases were in motor vehicle sales and healthcare spending. With respect to healthcare, a little bit counterintuitive, but the reason is hospitals reserving space for the COVID emergency and COVID patients, and all elective healthcare procedures and visits pretty much shut down. Of course, there are also big declines in clothing, recreation, and restaurant services, grocery buying was up. Some more recent data, like from this week, kind of tracking retail sales. There's some retailers on the phone. Obviously, retailing has fallen sharply. Fell 8.3% from February to March. Then sales were down 16.4% from March to April. So through April at a level of 21.6% less than last year. And the April decline is the biggest decline in retail sales on record. So just a few interesting data points. Sales were down 58.7% at furniture stores, 60% at electronic and appliance stores, and down 78.8% at clothing stores. Department stores were already in trouble. Sales were down 28% at department stores. You may have seen in the news, they're kind of hitting on a daily basis. JCPenney is shuttering and or spinning off its real estate assets and selling most of its stores. Pier 1 Imports, and there are other retailers on the way. Industrial production, massively down. The March to April decline compared to last year was 15%, which is the largest monthly decline in 101 years of tracking the index. The last time that manufacturing decline fell at this rate was in the months immediately following World War II, when factories that had been going full bore, were producing weapons for the war effort, suddenly shut down and had to retool to kind of reinvent themselves to get back into consumer goods. I mentioned, automotive products down 61% and down 70% year over year. Business equipment sales down. So obviously you know all that, just some interesting data. Of a special concern, I think, to everybody for various reasons, not just the economy generally, but for personal reasons, is what's happened with unemployment in our country. The 8-week total preceding now has unemployment claims up to 36 million. The number of people continuing to receive unemployment benefits is 22.8 million, which is up 450,000 from last week. There was a little bit of travel last month, but not much, and I think it's opening back up, actually. So one kind of interesting thought that I had as you're considering, and I'm not any kind of expert on monetary policy, and I'm not an economist. I know enough to be dangerous. One, because I pretend to read The Economist, and I stayed in a Holiday Inn last night. But one concern is inflation and what's going to happen with, and how's the government able to support all these economic stimulus packages. And I think the short, uncomplicated answer, although there's more to it, is because other governments buy our government debt in dollars, there's little to no risk of default on our foreign debt purchases. And so we can print money. It's got to be paid back at some point, but we really can print money. So the big danger in that circumstance for a recession based on that kind of borrowing and that kind of monetary policy is inflation, which means prices rise. So interestingly, on inflation, overall prices in April fell the most since the global financial crisis of 2008-2009, largely due to a sharp drop in energy prices. I'm sure you've all seen the price at the pump. Here in Sacramento, it is just mind-boggling. It's unbelievable. I mean, in the course of 6 months, you saw it go from, over $4 to $2.25, which is fairly staggering. So notwithstanding, take out that drop in energy prices, excluding food and energy prices, core prices still fell by the most since 1957, which is deflation, which is a concern for other reasons. But that said, I think concerns right now for inflation are overwrought. It may come to hit us in the future. The problem with inflation, obviously, is somebody made a chat to everybody. You're out of your mind saying we can just print money. Well, I'm not saying they can or they can't, but I'm just actually saying they did, So Economists are not terribly concerned about inflation right now, other than the fact that it is a big concern when you do print money, like the government is doing right now. World investors aren't so concerned about it when you look at their investment patterns right now. One really interesting thing that suggests inflation that I was reading is the increase in wages, and wages actually increased in April, which suggests a potential inflationary period. But what actually happened was the reason wages increased is because a lot of higher wage earners kept their jobs and all the lower wage earners lost their jobs. So that obviously affects the wage growth. So what does all that mean? Well, I don't know, but we are in a period of economic uncertainty. Obviously, there's going to be recovery at some point. We don't know what it's going to look like. You've seen discussion in the press about whether it's a V-shaped recovery or a U-shaped recovery, and just picturing kind of a graph in your mind, I think you can understand what that means. Some economists are now talking about a W-shaped recovery, where we are now kind of restarting the economy. Spending is going to go up. There's going to be some recovery, but there's also this kind of unknown and potential expectation that as the economy opens up, that there may be a future shutdown, if cases of the virus spike, which then result in another downturn, and then a potential recovery after that. And they call that a W recovery, which I thought was interesting, which I wasn't familiar with. So anyway, that's the little ride. I just thought that was some interesting data. And I think the takeaway and the point of all that is you got to be planning for the future. You got to understand businesses are changing. The way we all do business is changing, not just with respect to where we work, what effect this current environment has had on our expectations of, for example, what kind of office space do we actually need? Depending what type of industry you're in, your product may have to change, your projections may have to change, and all those things. So keeping track of that economic data beyond just interesting, I think the only takeaway I have is you got to be proactively planning for the future and not just hoping for the best. What's the phrase? It's like hope is not a strategy or something like that, and it's not. So it is really difficult to plan in these circumstances, but planning can include taking into consideration multiple different scenarios. So anyway, that's all I had to say about these economic indicators. One thing I wanted to touch on that jumped up very recently, and as of last night, and then actually is in front of the State Senate Judiciary Committee today, is what would be a huge sea change, and I think a really difficult new California law that proposes to ban commercial evictions during the state of emergency. So it's a commercial eviction moratorium that also provides for additional tenant protections for certain industries. It's California Senate Bill 939, and it proposes a new section 1951.9 to the California Civil Code. I think there's a hearing today in the State Senate Judiciary Committee, and I'm not sure, I'm not up to date on what the expectation is about what is to come out of committee today, but this is something that every tenant, landlord, and lender, if you're a lender on property that has tenants, needs to be advised of and know about and be tracking like immediately, because it may affect you very soon. So the bill restricts landlords from pursuing eviction proceedings or imposing late fees for all commercial tenants during the current state of emergency. And then for certain industries, what they call qualifying tenants, it forces landlords to engage in and negotiate rent reductions if the tenant requests. Some little caveats to that, which are kind of, this actually isn't a law yet. It may be about to be, but it would apply to, businesses that operate primarily in California. And the category of qualifying tenants, which are afforded these negotiation and termination rights I'll talk about, are small businesses or an eating or drinking establishment or an entertainment or performance venue suffering a COVID-19 related decline in revenue or capacity. So there are other commercial moratoriums in different jurisdictions issued by counties Most of them require a tenant to demonstrate COVID-19 losses. And while that might not be hard to demonstrate, this proposed bill, as I understand it, applies to all commercial tenants, and a showing of losses due to COVID-19 is not required.
What's the bill number?
939. Additionally, the proposed legislation provides that if a tenant does not pay rent during the current state of emergency, the tenant will have 12 months following the end of the state of emergency to pay the amount due, and a landlord cannot impose late fees on unpaid rent during the current state of emergency. And so from a timing perspective, I believe the state of emergency was proclaimed by Governor Newsom on March 4th, 2020, and is still in place. In addition to that broad commercial eviction moratorium and ability for the tenant to repay back rent over 12 months, certain types of businesses as tenants are allowed rent negotiation protections. So for those industries I described just earlier, in that instance, the tenant does have to show a decline of 40% or more of monthly revenue as compared to either the 2 months before the shelter in place took effect or the same 2 months in 2019, or if an entertainment or performance venue, a 25% decline in capacity due to social distancing orders. So for businesses that satisfy those conditions, there is the bill isn't that long. It's a short, it's just a few pages, and the proposed statute's only just 4 pages. And so it appears to allow a tenant that satisfies those conditions to notify its landlord that it meets the criteria under the statute and makes a request for lease modifications, including rent reductions. And then listen to this. If the parties do not reach an agreement within 30 days of the notice, then the tenant may terminate the lease without liability for any amounts owing after the termination date. And I'm just, my mind's kind of blown by that. You know, there's something in the United States Constitution called the Contracts Clause. I'm not sure if that is related to this or runs afoul, but that is just a massive sea change and something that every landlord and tenant and lender needs to be aware of. And by the way, it goes on, and this is now the subcategory of restaurant and entertainment venues. For the prior rent due, the tenant's liability is limited to the sum of 3 months' worth during the state of emergency. And all other amounts unpaid related to COVID-19, and that amount is not due until 12 months after the lease termination date. Well, depending on what type of tenant you have, and by the way, I'm thinking movie theaters actually. This is a big problem. I mean, movie theaters are very large anchor tenants for shopping centers, and you can imagine what this is going to do to shopping center owners. I happen to know that certain movie theater operators are actually not paying any rent right now, and I don't know if they have a lobbying group involved with this bill or not, but those are fairly big spaces. As currently proposed, the law would be in effect until the later of December 23rd, 2021, or 2 months after the end of the state of emergency. So I don't know what you all think about that, but it's fairly scary. And if you're a landlord or a lender, if you're a tenant, it's something that you may or should or want to take advantage of. So just a few other comments about kind of what I'm dealing with various clients in various industries is this current kind of, I'll call it the tenant landlord lender dance, you know, and it's kind of this question of how is all this working? Tenants aren't paying rent. Owners have loan payments that come due. Lenders have loan portfolios. Lenders are come in all different shapes and sizes. I read this morning that the Mall of America, which I think is like the largest mall in the United States in Minnesota, has a $1.4 billion CMBS loan that it just defaulted on. And that's a big loan. And you can imagine nobody's going to the mall. So this problem isn't going away anytime soon. And then what's interesting to me is about, with respect to this new proposed section of the California Civil Code, and also kind of tying it into the form of the economic stimulus package that the government is providing right now. It's all about kind of like law shifting and who's going to bear the brunt of this right now. And, you know, just in the commercial real estate, I'll just kind of focus narrowly right now on that part of the economy. Right now, it appears that the loss is going to be falling on the landlord owners. There are some restrictions on what lenders are able to do with respect to their loans, but it feels to me right now that the landlord owners are getting stuck in the middle. I was just looking at our participant list, and if I'm not mistaken, I don't see any banks on the list, although there may be some private lenders, or maybe you or your business has a private investment loan or something like that. So I won't say much about banks. If you're a private lender, my advice to lenders right now is to be flexible, but also to protect yourself with respect to documenting any changes to loan documents appropriately, whether it be forbearance agreements or amendments to loans. Get what protections you may need in those documents, but still be flexible. From a tenant perspective, this new proposed statute may be some of assistance to you, but what I think you also need is to reach out, be proactive, make a specific request for relief, provide data, give financials, and my suggestion is actually propose something. Instead of calling up the landlord and saying, hey, I can't pay rent and I don't know when I'm going to, one thing that landlords appreciate is actually some kind of proposal that they can use, because they have lenders that they then have to go to as well to base on. I would also note that you've got to sequence, if you're a tenant, multi or single space tenant, and you have a PPP loan, you also got to think about and come up with a forgiveness strategy about whether you're going to pay rent or not. So, you know, for example, I believe the current formulation is up to 25% of your PPP loan is forgivable to the extent it goes to pay rent. Well, you may or may not want to actually use it for rent. If you do use it for rent, one strategy, I mean, that may be fine because that component is going to get forgiven. But on the other hand, maybe you have a better use for that money that you then have to pay back, or that comes due in 2 years at 1% interest. From a landlord perspective, just a few notes before I finish. My notes are, look at, you know, be aware of what your rent rates are. If they're above market, now might be the time to adjust. It also is going to depend on your tenant mix. What you got to be in contact with your tenants. You should be able to understand everybody's at short-term risk. You know, shopping center tenants aren't paying any rent right now, but trying to understand your customers, your client's business, i.e. your tenants, to get an understanding of who's at medium or long-term risk. You know, who's going to be in business 6 months from now, who's not, is a good question to be trying to understand. So ask for financials, be proactive and communicate, be flexible. I advise that, you know, as a landlord, partner with your tenants, engage in some joint marketing, try to come up with a mutually beneficial solution. There's a small shopping center here in Sacramento at the corner of Fair Oaks Boulevard and Fulton called Loman's Plaza, which is just a little shopping center. And there's a big, huge sign out front that's very generic looking that says, restaurants here are open. And I imagine it's the owner who put that up to help drive traffic to his tenants, i.e. help the tenants to help yourself. Lenders are overwhelmed right now. If you're a landlord with forbearance requests, with, you know, requests for modifications, and so you have to be patient, but you do have to document everything, and you do have to engage in that regard. So I went overtime, and I apologize for that. I was a little bit wordy. I think we're going to end it there, and I guess I'll end it with just saying, you know, two things. One is it's a 3-day weekend coming up, so it's Memorial Day weekend. It's a gorgeous day right here in Sacramento, so enjoy the weekend. And also, I urge you all to be cognizant of the fact of the purpose we celebrate Memorial Day, which is to honor those who are lost in active military duty. With that preface, I will say happy Memorial Day and enjoy the weekend. Thank you, everybody.